Hello. For those of you who haven't met me, my name is Sarah Ash. I'm a group partner at Walkers and an employment specialist, and I'm joined today by my colleague Danielle Brouard, who's a senior counsel in my employment team. And today we're going to be taking you through course 4, which is our Service Providers Responsibilities course. So what are we going to cover today in our session? We're going to be looking at who the ordinance applies to outside of the work context, so outside the employment relationship. We're going to be looking at some examples of discrimination and other types of prohibited conduct under the new ordinance. We're also going to look at the process for bringing claims and the remedies. And we're also going to look at some of the exceptions that are set out in the ordinance that are relevant for service providers. So, starting off with, who does the ordinance apply to? As you can see from the slide, the ordinance applies to service providers, schools and education providers, clubs and associations, and accommodation providers. It does, of course, apply to employers, and we've already had a session which has been dedicated to employers' responsibilities. Today, we're going to cover in a little bit more detail under all these areas. Turning firstly to what is a service provider. So a service provider is a person who provides goods, services or facilities to the public or a section of the public, whether for payment or not. So an example of a service provider might include shops, restaurants, transport providers, entertainment and leisure providers, banks, insurance providers or hotels and tradespeople. And it's important that a service provider must not discriminate against or victimise another, for example, by refusing to provide goods, services or facilities. So an example of that might be refusing somebody entry or refusing to serve somebody. They must also not discriminate or victimise as to the terms on which they provide goods, services or facilities. So, for example, if they were to offer more favourable terms to locals than those not from the bailiwick, for example. They must not discriminate or victimise in the manner in which they provide their goods, services or facilities, or by terminating the provision of goods, services or facilities, including by requiring a person to leave their premises, for example. And neither must they harass anyone requesting or using their services. So what is a school or education provider under the new ordinance? A school is defined as an institution for providing primary and or secondary education, whether maintained by the states, independent, or in receipt of grants from the states. And an education provider is any other institution in Guernsey at which education is provided for 5 or more students of any age, including registered preschools and day nurseries, or an organisation which develops or accredits curricula or training courses for use by a school or educational institution in Guernsey. And it's important to note, as set out at the bottom of this slide, that duties on schools and education providers will not come into force before 1st of September 2025. The responsible body of a school or education provider must not discriminate against or victimise a person in the arrangements made for deciding who's offered admission as a student, by not admitting a person as a student, in the way that education is provided, or by denying access or limiting access to any benefit, facility or service, by permanently excluding a student, or by subjecting a student to any other detriment. And again, neither must they harass a student or someone who's applied for admission as a student. So what is a club or association? An association of persons other than a professional or trade organisation. It must have at least 25 members and rules regarding admission to membership. It does not matter if it's carried on for profit, and clubs and associations which do not meet this definition will usually be service providers. Now, potential examples of clubs or associations. These might be organisations established to promote the interests of their members, such as an association of disabled people with a particular impairment or condition, or a club for parents. Private clubs, they might include sports clubs, for example. Associations for people with particular interests such as fishing, music, gardening, or wine tasting. We also see children's clubs and political associations. And a club and association must not discriminate against or victimise a person, for example, in the arrangements made for deciding who is offered membership, as to the terms on which people are offered membership, by not offering a person membership in the terms offered, in the terms of membership that are offered, by refusing or failing to accept a person's application for a particular class or type of membership, by denying or limiting access to any benefit, facility or service provided by the club or association, by depriving a person of membership, or by subjecting a person to any other detriment, and neither must they harass a member or anyone who has applied for membership. What is an accommodation provider? So an accommodation provider is a person who has the right to dispose of property, for example, by selling it, subletting it, or otherwise parting with possession of it, whose permission is required for any of the above things, or who manages premises which are occupied. Now, it does not include people who run hotels or self-catering accommodation. They will be covered as service providers instead. So accommodation providers, for example, will include estate agents, landlords, and individuals who rent and sell property. It also includes services provided by the states and charities who provide accommodation or accommodation services. And an accommodation provider must not discriminate against or victimise another person as to the terms on which they offer to dispose of premises, by not disposing of premises, in respect of things done in relation to other people seeking premises, by not giving permission for the disposal of premises, by denying or limiting access to any benefit, facility or service provided by the accommodation provider, by evicting or taking steps for the purpose of securing eviction, or by subjecting a person to any other detriment in respect of the provision of accommodation. And an accommodation provider must not harass a person who occupies premises, applies to occupy premises, or applies for permission to dispose of premises, or a person to who a disposal would be made if permission was given. I think it's important to note that an organisation may have duties under more than one section of the ordinance. So a service provider will also usually be an employer and will therefore have responsibilities as an employer under the ordinance, as well as its duties as a service provider. In some circumstances, they will also be an accommodation provider and or a club. So for example, an estate agent that manages properties will likely be an employer, a service provider, and an accommodation provider. And a sporting organisation which provides tuition for members and also runs children's birthday parties will probably be an employer, a service provider, and a club. And just one point here around charities and voluntary organisations and how they may fit into this. Now, it will depend on what they're doing, but they will usually be service providers and employers. But it is worth noting that if an organisation is staffed partly or wholly by volunteers, volunteers will not come within the scope of the ordinance, but clearly it's best practice not to discriminate against them either. So when will these duties come into effect? Well, first of all, just to point out that the new discrimination ordinance is largely coming into force on the 1st of October 2023. And at that point, we're seeing the introduction of these new protected grounds. But I've set out on the slide here some other dates which are relevant to be aware of. So any requirement to make physical changes to premises is not going to be before the 1st of October 2028. I mentioned earlier when I was talking about schools and education providers that obligations on them are not coming in before the 1st of September 2025. In addition, there's going to be a 2-year delay before claims can be brought in relation to contracts other than employment contracts and leases. So there is some time for service providers, clubs and associations, schools and education providers and so forth to prepare in advance of these changes coming into effect. I'm now going to hand over to Danielle, who's going to cover some examples of discrimination and other prohibited conduct.
Thanks, Sarah. Anyone who's attended courses 2 or 3 will already be familiar with the main types of discrimination and prohibited conduct that are covered by the new ordinance. But we wanted to run through them again briefly now, and in particular provide some examples in the service provision context. Firstly, direct discrimination is treating someone less favourably because of a protected ground. So in a service provision context, this could include, for example, refusing to serve a customer in a cafe because of their race, or a hairdresser refusing to cut someone's hair because of their perceived sexual orientation. Discrimination by association is treating someone less favourably because of their association with someone else who has a protected ground. So that could cover, for example, a landlord refusing to lease a property to a tenant who has a disabled family member. Indirect discrimination is where you apply a provision, criterion or practice which puts those who share a protected ground at a particular disadvantage and which cannot be objectively justified. So, for example, if a gym required all new gym inductions to be carried out on a Saturday, this might put practicing Jews at a disadvantage because they need to observe the Sabbath. And if that's the case, then the gym would need to decide whether they can objectively justify that decision only to run gym inductions on a Saturday. Discrimination arising from disability is where someone's treated unfavourably because of something arising in consequence of their disability, where this cannot be objectively justified. An example might be a private members club, which rejects an applicant's application for membership because they're unable to attend its monthly meetings. Now, the rejection of the membership would be unfavourable treatment. And if the reason why that applicant cannot attend monthly meetings is related to their disability, it will be unfavourable treatment because of something arising in consequence of their disability. So again, the service provider here, the club, would need to see whether they could objectively justify their rule that members need to attend the monthly meetings. And this would involve looking at whether there were any more proportionate alternatives. So, for example, whether it was possible for the person to dial in if that was something they could do, or send someone in their place to report back to them. And that example I've just mentioned could actually also fall within the test for indirect discrimination, which illustrates how sometimes certain facts can fall within one or more types of discrimination under the ordinance. Another example of discrimination arising from disability might be a situation where a person with a learning disability is in a shop and is asked to leave that shop because they've become distressed. Now, if the shop have reason to think that the person's behaviour is related to an underlying disability, or if they ought to have known that, then again, that could amount to discrimination arising from disability. And the question would be whether it was proportionate for the shop to ask the person to leave. If they were disturbing other customers, for example, then they may have been trying to pursue a legitimate aim, but could they have done something more proportionate, such as speaking to the individual concerned or their care worker, if they have one present, to find out whether there's anything you can do to help, or a quieter area of the shop they could move to for a bit. And I've just mentioned when discussing that example that this would apply if the shop knew or ought to know that the person was disabled and that the the behaviours were related to the disability. That's an important part of the test for discrimination arising from disability. So the duty won't arise unless the duty holder did know or ought to know that the person was disabled. Harassment is unwanted conduct related to a protected ground or of a sexual nature, which has the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. So an example of this might be a party of adults with learning disabilities having a meal in a restaurant accompanied by their support workers. So if some of the restaurant staff were to make fun of the party, then the support workers would understandably likely become upset about that. And the support workers in that instance could bring a claim potentially for harassment related to disability. And that example illustrates the point we've mentioned in previous sessions, that the conduct that is unwanted needs to be related to a protected ground, but doesn't need to be related to a protected ground that the people who are offended by it themselves possess. Individuals can also bring a claim for harassment if they are harassed, they reject or submit to that unwanted conduct and are then treated less favourably as a result. And that's quite similar to the separate offence of victimisation, where someone's treated less favourably because they've complained about discrimination or supported another person's complaint. So some examples of that in the service provision context could include a situation in a pub, for example, where a barmaid has made derogatory comments about a customer's sexuality and the customer complains of discrimination. If the publican then bars that customer from the pub in retaliation, that would be victimisation. Equally, if a landlord makes a comment in front of their tenant about people of a certain race, which the tenant finds offensive, and then the tenant complains and the landlord refuses to renew the lease, again, that's likely to be an example of victimisation. The duty to make reasonable adjustments applies where provision, criterion or practice, physical feature or lack of an auxiliary aid puts disabled people at a substantial disadvantage in comparison with people who are not disabled. And where that applies, the duty holder must take reasonable steps to avoid the disadvantage or provide the auxiliary aid. Now, in the service provision context, and in relation to schools and education providers, it's really important to note that the duty to make reasonable adjustments is not just a reactive duty. Those organisations also have a proactive duty to think about adjustments that potential service users and students may require before they are actually requested. So in terms of examples, so an example of a reactive duty to make reasonable adjustments of the service provision context might be a small shop. They might have some display units at the entrance to the shop, which could restrict a wheelchair user's ability to enter the shop. If a wheelchair user wants to come in the shop and they ask whether the unit can be moved, if the owner looks at this and decides that actually that unit could be easily moved, in fact on a long-term basis without any significant impact on selling space, etc., then it would be probably reasonable for them to take that step and move the unit. In terms of the proactive duty, I'd give the example of a library which has a number of computers for the public to use, and that library will be under a proactive duty to consider whether any adjustments may be required for disabled people who might want to access those computers. So, for example, one potential adjustment might be text-to-speech software for people with a visual impairment. And if that type of software is available and within budget, it might well be reasonable for the library to install that software as a proactive, reasonable adjustment before it is even requested by a specific individual. We now have a video we'd like to show you.
We have a client who is partially deaf, becomes, when hearing aids are out, virtually impossible to hear. So, which unfortunately with a haircut you have to take hearing aids out most of the time. We make sure we get all the details done before the haircut. And I've cut that client's hair for 3-4 years now, and it's never been an issue. We've never ended up with like a mohawk or anything like that because he couldn't tell us. It's just all these things are done very simply, and you think about it. And if anything, it's only made my business and our business where we are stronger and better within the community. We've moved our premises, it's up another level of stairs, so it's really not accessible for anybody who does require a wheelchair, unfortunately. So in order to combat this, it's not hard really. We allocate some time where we can do some home haircuts, we can do home visits, and we did have a premises as well that we were able to sort of dedicate to wheelchair users. But failing that, if it's something that we decided in the plans it wasn't financially working out or whatever like that, we can do home visits and sort of still give people the service they require, just the comfort of their own home. Really, that was our way of helping with that kind of issue.
Certainly, from a site point of view. It actually going into the premises, the original premises was where I started off with them, telling me where the chair is or what he's going to be doing next. If he's suddenly going to spray water at my hair to damp it down, he does tell me first. When he's got near the end of a haircut, it's fine for me to feel to see whether it's how thick I want it or how long I want it, so that I can judge my haircut just as well as anybody else does. I just have to do it slightly differently. And in some settings, I feel quite awkward doing things differently. I just want to blend in with everybody else. I don't want to be treated as special or different. But I still want to be able to make those choices and go, actually, can I have a bit more off the back? So it's an environment where I can get that same haircut as everybody else. When they moved premises, he gave me a ring just beforehand and met me at the old place. It's only a couple of minutes up the road. Showed me down the road, made sure that I knew where everything was, where the waiting bit was, where his chair is. And even now, if there's been a delivery that's, kind of where it wouldn't normally be, he'll just say, it's like, okay, there's some boxes just on your left and I've turned the chair around so it's facing you. Those little things actually make a huge difference. And asking about whether the booking system works with my assistive technology, yep, it does, but it's really nice to be asked. And, if it hadn't been okay, then I'm sure that we could have worked out a system for me to book. From the autism side, the first time which I was basically non-verbal, I was really overloaded, and I still needed a haircut. And I wrote it down on a piece of paper. I hadn't been going to him for long at this point. And I just wrote down, look, this is who I am, where I'm at. Handed him this piece of paper and he just read it. Not, questioned me as to why I'm being handed a piece of paper, which happens in some places. He just read it, and he actually took me through to like a back part of the room. I got on with it and didn't speak, didn't try and make me do chit chat. And within that, there wasn't any awkwardness. And that is huge. I could still get that. I can go no matter how I am. And if I'm chatty and I'm really on form, that's great. But I know that if I'm not, it's still okay. I still need to use a bank. I still need to post parcels. I still need to get groceries. I still need a haircut. I still want to go for a coffee with somebody. I will go places that I'm able to access and I feel comfortable. If I've got a choice between a really busy, noisy place where I feel rushed and I'm like discounted because I'm different or they might need to do something a bit differently, I just won't use there. I'll use somewhere which does welcome me.
I'm now going to move on and look at bringing claims and remedies. I've set out on the slide here the formal process to be followed in this context. Now, as you can see from the top, notifying the potential respondent about the complaint. Now, you could, as a first port of call, consider using an organisation's internal complaints process in the first instance, if they have one. And I would say if anyone were to receive a complaint in this way, it's advisable to deal with this promptly, as this will hopefully reduce the risk of a formal complaint being made. So if complaints are received, don't ignore them. Try and deal with them first in this sort of informal way as much as possible. There are various formal steps that are required before someone can bring a claim, and it's very important that you're aware that there are relatively short timeframes involved here. So in terms of the formal steps required to bring a claim, written notification needs to be given to the intended respondent within 6 weeks of the discrimination occurring, giving them a month to resolve the issue. So again, it's important to respond quickly if you do receive sort of written notification of a complaint. At the next point, if the complaint is not resolved, then the next step would be to move on to notify the Employment and Equal Opportunities Service, EEOS. And EEOS will then explore whether or not the parties wish to engage in any sort of pre-claim conciliation. Now, it's again for pre-claim conciliation, it's obviously important that both parties agree to this and both parties are prepared to engage in this. If one party is not interested, then that pre-claim conciliation will break down and fall apart. So it needs both parties to be engaged, but if both parties are willing to engage, it may be possible to resolve the complaint at that point, which will end the process. If the complaint is not resolved, then a formal complaint may be at that point made to the Employment and Discrimination Tribunal. And any claim must be brought within 3 months of the act complained of. However, as with an employment claim, if time is spent engaging in pre-claim conciliation, that will pause the clock. So essentially, you won't be penalised if you've tried to engage in that pre-claim conciliation, but for some reason it's not worked. You won't lose that time. You will still have the 3 month time period to bring your complaint. And the tribunal also has discretion to extend time in certain circumstances. Moving on now to remedies. If a complaint is upheld in the tribunal, then the tribunal will look to see whether or not there have been any financial losses. And it may be that an award of up to a maximum of £10,000 for financial losses may be awarded. However, this may not be relevant in every case. Not every case will have a financial loss associated with it. In addition to financial losses, the tribunal will also look at an injury to feelings award, or injury to feelings, hurt or distress. And this is an award of up to £10,000. Now, this is also relevant in the employment context. And just to explain a little bit more about what injury to feelings may be, because this is a new remedy that we're seeing brought in by the ordinance. This is an award to compensate for the effects that a discriminatory act has had on a particular claimant, and the size of the award will take into account factors such as the degree of hurt, distress or upset caused and the seriousness of the treatment. The tribunal will also consider whether the discrimination was a one-off incident or a course of conduct. But it's important to note that a very serious one-off incident could result in a high-level award. Now, we're yet to see the confirmed bans, but we expect that the Committee for Employment and Social Security will be recommending 3 bans, likely to be a lower band of £500 to £3,000, a middle band of £3,000 to £6,000, and an upper band of £6,000 to £10,000. And of course, this award is going to be particularly important in these non-work related cases where it may be the only financial award relevant or to be given. Where a person has 2 or more complaints relating to the same facts and circumstances, the above limits will still apply, unless, and this is the main exception, one of the claims is for victimisation, in which case the person could potentially obtain a further award of up to another £10,000 for financial loss and up to £10,000 for injury to feelings, hurt or distress in respect of the victimisation claim. And this is similar. Victimisation is treated as a separate head of claim in an employment context as well. The Employment and Equal Opportunities Service can also issue non-discrimination notices requiring service providers to cease discriminatory practices. So this is important because, as well as having a financial consequence, this could also be held on public record, and this could lead to reputational risk and potentially the loss of future business. So receiving one of these notices will also potentially be problematic for any business. I'm now going to hand over to Danielle, who's going to talk through some of the exceptions.
Thanks, Sarah. So by now, you should all have a pretty good understanding of the various types of discrimination and prohibited conduct under the new discrimination ordinance. But there are lots of exceptions to the general principles, in particular in the service provision context. And so we wanted to spend some time running through those. Starting with providers of goods and services, we have an exception for financial services businesses which involve an assessment of risk, such as insurance and pension providers, and they are permitted to take into account disability and/or race where relevant and reasonable to do so. An example of this would be a travel insurance provider. If the evidence shows that people with specific disabilities are more likely to need to seek treatment abroad whilst on holiday, then those providers are justified in charging higher premiums to those individuals, and the discrimination ordinance allows them to do that. Next, a pension scheme or occupational benefit scheme may provide ill health benefits to one or more disabled people and not to others, or different benefits according to the severity of the disability. So, for example, a permanent health insurance provider might have rules as to when someone qualifies for that benefit and might offer different levels of benefits depending on the extent to which someone is unable to work. And that, again, is permitted under the ordinance. In relation to dramatic performances and entertainment, it's not discriminatory on grounds of disability or race, to do anything reasonably required for the purposes of authenticity, aesthetics, tradition, or custom. So that would allow a director of a play or film, for example, to cast a disabled person to play a disabled role, or to require a white woman if they're looking for someone to play the part of Queen Elizabeth II, for example. There are some exceptions in the religious context, which is important to bear in mind. So, for example, a service provider can restrict the provision of goods and services which are for the purposes of a particular religious belief to people of that belief. So Christian churches can restrict Holy Communion to people of the Christian faith, for example, and a service provider can restrict the use of religious premises on the grounds that allowing use would not comply with the principles of the religious belief. So if a church has a church hall which it rents out to various groups, and a LGBTQ plus campaign group want to rent the room, the church could, if it wishes and considers the principles of the group wanting to hire the hall to conflict with its religious beliefs, it could refuse that booking. Broadcasters and publishers can exercise editorial discretion over their content to be able to publish a range of views and permit free speech. So, for example, a radio programme could produce a programme which shows a range of views on a topical subject such as immigration, and it could do that without facing claims for harassment from listeners who are offended by the views of anyone it interviews. And finally, on this slide, information society service providers who provide services through a website would not ordinarily be held responsible for the content of the data that they process. So, for example, if a charity hosts a chat forum, an online forum on their website, and someone on that forum makes an offensive post about disabled people, the charity wouldn't face liability for that, not usually anyway, provided that once they become aware of that post, they take it down relatively quickly. Moving on to exceptions which apply in the education context, schools can arrange for pupils to be selected based on ability or aptitude. So non-state schools can continue with their entrance exams, but they would, of course, still need to comply with their duty to make reasonable adjustments in relation to those exams. Schools with a religious ethos can discriminate on grounds of religious belief in relation to admissions. So it's quite self-explanatory. Religious schools can give preference to religious potential students in deciding who will join. Curricula do not have to represent people with particular protected grounds. So, if you have a set of, say, maths questions, someone can't raise a complaint that not enough of the names of the fictional characters in those maths problems have names that would be normally associated with people of different ethnicities. The next exception is religious schools can teach a curriculum which focuses primarily on the religion of the school, provided that the curriculum also teaches that other religious beliefs exist and are deserving of respect, which again is quite self-explanatory. And it's not discriminatory to arrange for a pupil to receive additional or alternative educational services to meet the assessed needs of that pupil. So it's not discriminatory for a child with special educational needs to be given additional one-to-one teaching resources, for example, if that's been assessed as a need they have. And it's not discriminatory to move children to specialist schools such as Le Rondin or Le Murier, if that's been determined to best meet their educational needs. Now for clubs and associations. This is quite a wide exception for clubs and associations, firstly, on this slide, that allows them to restrict membership to people who share a protected ground, unless that ground is colour. So you could have, for example, a club who restricts their membership to people who have autism. Or you could have a club for South African expats in Guernsey, and that is fine. A club or association can exclude a disabled person from participation in sport if that person is unable to perform the actions required for the rules of the sport, despite reasonable adjustments. So a football club could potentially restrict a person with a learning disability from joining if the nature of the person's disability means that they are unable to understand or comply with the rules of football. A club or association can select people for their sports team or a sporting event based on skill or ability, as you may expect. So, if someone doesn't get selected for a basketball team, and the reason they don't get selected is because they don't process information as quickly as some of the other players on court, or react as quickly, even if the reason why they don't process information as quickly or react as quickly is due to a disability, they wouldn't have a claim under the ordinance. And then finally on this slide, it would not be discriminatory to treat people differently according to disability, nationality or national origin when providing sporting facilities or organising events or other competitions where this is justified. So I believe this is intended to cover things like if you're organising a parasport event, then you can set rules that require people to have a disability to enter that event. Or if you're selecting a team to represent the island of Guernsey, you can put in place criteria about who can do that based on nationality or similar. In relation to accommodation, it's important to note that private disposals of residential property fall outside the ordinance. So private disposals are those where an estate agent isn't used and the property is not advertised. So if I decide to sell a property without advertising or using an estate agent and two people I know are interested, the person who I don't sell it to can't claim that my decision was based on a discriminatory motive and bring a claim on those grounds. Disposals or letting of accommodation in a person's own home or the home of a close relative also fall outside the ordinance. So this doesn't apply to people running guest houses, and it does not apply to people letting out a separate and self-contained wing. But somebody can decide, for example, that they only want a lodger who shares their own religion or indeed is not religious, and they can do that without falling foul of the ordinance. Just a few more exceptions in relation to accommodation. Social housing providers, so for example, the States of Guernsey or Guernsey Housing Association, can allocate housing in accordance with a person's need without this constituting discrimination on grounds of carer status, disability or race. So these providers could assess someone as needing an extra bedroom, for example, due to disability or caring needs of somebody in the family, and another person cannot claim that it's discriminatory, that decision is discriminatory. Accommodation providers can provide accommodation which caters for the needs of people with a particular protected ground. So, for example, Guernsey Housing Association can continue to provide autism-friendly properties. And someone who decides to take in and care for another person in their own home cannot be found to have discriminated, either in the provision of services or accommodation. So, for example, foster carers can't face claims under the ordinance in relation to the care and accommodation that they provide. Moving on, there are some exceptions that apply in the health context. So firstly, anyone with duties under the ordinance can discriminate on grounds of disability if the disability is an infectious disease and the discrimination is necessary to protect public health. So quite a simple example of this would be a swimming pool can refuse entry to someone with a verruca who doesn't have that verruca covered because that could be infectious and could be a risk to others. Or a massage therapist could refuse to treat someone with an infectious skin condition if there is no other way to effectively mitigate the risk of transmission of that condition. A blood donation service can refuse to accept a donation of blood due to the risk to the public or the individuals themselves. So, for example, if the rule is that you can't donate blood if you've travelled to certain countries in the last 6 months or a year, that might have a disproportionate effect on people of certain nationalities who are originally from those areas, who may be more likely to travel there, but they could not bring a claim for indirect discrimination in those circumstances because there's this exception in the ordinance. A registered health professional does not discriminate by exercising their clinical judgment to treat a person differently. So a doctor could obviously decide to offer certain treatment to one individual, but not to another individual based on their clinical judgment. But obviously, if they're basing it on something else than their clinical judgment, if they are actually prejudicing people for other reasons, then they could face claims. It's not discriminatory to offer preventative public health services to members of the public based on clinical or other data. So I believe that certain people in Guernsey qualify for free annual checkups, such as people with diabetes, for example, and the states of Guernsey can continue to offer that service only to those specific groups. And then finally, a person who lacks capacity can be treated differently where reasonable to do so. So an example of this would be a bank who decide not to offer loans, they can't offer loans to individuals who, due to a disability, lack the mental capacity to agree to the necessary terms. So I understand that that's the kind of scenario that exception is designed to cover. Now, it's worth noting that these are not obviously all the exceptions that would apply to service providers and the other types of providers we're talking about today. There are also some general exceptions, such as the ability to take positive action, which were covered in session 2. If you haven't already attended session 2, I would recommend doing so, because there might be some other helpful exceptions that you can rely on there. And finally, the ordinance makes it clear that service providers, schools of education providers, accommodation providers and clubs and associations do not have any duty to fundamentally alter the nature of the service that they provide. So an example would be, a nightclub wouldn't have to turn down the music because that might help people with certain hearing impairments or sensory processing disorders. A wine tasting club wouldn't have to provide tastings of soft drinks just because certain people, whether for disability or religious reasons, aren't able to drink alcohol. And a children's club offering messy play facilities wouldn't need to offer different activities because a certain child who may have sensory issues prefers other activities. So that's just some examples of that. Finally, I'm going to pass back to Sarah to cover what service providers can do to prepare for the new ordinance.
Thanks, Danielle. So what can service providers do to prepare? I think firstly, the important place to start is ensuring that any staff that you have are aware of their obligations under the new discrimination ordinance. One thing that may be helpful is to think about providing training for your staff. This will certainly help raise awareness of the new discrimination ordinance and any obligations and requirements under it that staff should be aware of. In addition, you may want to consider things like training around general sort of behaviours at work, your expectation around anti-harassment and bullying, giving guidance around inclusive language and so forth, which will be helpful within your organisation and also obviously when dealing with customers and clients. In addition, it would be sensible to review your policies and procedures and ensure that you do have the appropriate policies and procedures in place and that none of these are going to fall foul of the requirements under the new discrimination ordinance. Service providers should also be reviewing how accessible your service actually is. And we'd recommend focusing in particular on the proactive duty to make reasonable adjustments, although bearing in mind that some aspects of this duty will not be implemented straight away, but others will. In addition, you could consider undertaking an access audit and preparing an accessibility action plan. Now, we will be covering a lot more detail on this in our session 5, which is a whole session which is focusing around reasonable adjustments and accessibility. So I'd really encourage you, if you haven't already, to sign up to that session and hear a little bit more in detail about these areas and how you can take that forward to prepare. In addition, for landlords, they should be reviewing their rental terms to check whether they may disadvantage protected groups, and if so, whether any changes are necessary. Any clauses that prohibit a tenant from making physical changes to the property may also need to be modified, as any disabled tenants will have the right to make certain changes to the property at their own expense. For example, the addition of grab rails or other changes to fixtures and fittings. Adjusting sort of cupboards or door handles or so forth to make it easier access, those sorts of things. Schools and education providers should start considering whether any of their admission criteria or other policies and procedures could be deemed discriminatory, and if so, whether there are any defences or exceptions open to them under the new discrimination ordinance. And finally, clubs and associations should review their membership rules and other policies and procedures to ensure that they're not discriminating against protected groups either directly or indirectly. In addition, I would just like to flag up that there will be some detailed guidance notes that the states are currently preparing, and those will be coming out in advance of the legislation coming into force. These will be a really useful, helpful resource that service providers and employers can look to provide additional information and guidance in certain questions. In addition, EEOS will also be a valuable source of resource to employers and service providers should they have questions.